The International Lawyers Network's Trust and Estates Specialty Group welcomes you to Passport to Trust and Estates, U.S. Issues for Canadian Estates.
The earlier presentation by the Toronto and Vancouver offices dealt with the Canadian issues, and we're going to deal with the U.S. issues. We've tried to keep the presentation in the same format as the former presentation so that you can see the differences more clearly. We're going to start the presentation by looking at Canadian persons with U.S. recreational properties. And so we're going to start with my partner, Amy Fraccassini, who is a shareholder in our real estate group. My name is Donna White. I'm a shareholder in the Trust and Estates group. And to my right is Brian Gaudette, who's a shareholder in our tax group. If you have any questions, we're going to hold the questions until the end. If you're watching this via web, please feel free to type in any questions you may have as you think of them. So with that, I'd like to turn to Amy Fraccassini. She's going to start the presentation by talking about some of the transactional issues that you might encounter with clients who are purchasing real estate in the U.S. and some of the pitfalls that you may encounter.
Good afternoon. So I'm going to just, like Donna mentioned, touch on some of the transactional issues and sort of give a brief overview about some of the things that are traps for unwary that you should be careful about when you're buying United States property. The first thing I'd like to just, it's presumed that you're going to retain a broker to help you facilitate the purchase of the property. And in the United States, and I guess I should start and point out that every state is different, and there are nuances in every state with respect to how these things work. So we're going to focus on most of the Northeast, and to the extent that I can highlight some specifics in other states where things might vary a little bit, I will definitely do so throughout the presentation. So the first slide is that it's presumed that you're going to procure a broker to help you facilitate the acquisition of the property. And whether it's a residential property or commercial property, many of these same things apply. Most brokers represent a seller in a transaction. So even if you're the buyer and you call up a broker, be forewarned that in the United States, the broker represents the seller unless you specifically hire them as your broker, which is a buyer's broker. Many brokers will also ask if you would consent to dual agency, and you will sign a contract to that effect. So in that context, they're representing both the buyer and the seller, and there's no problem with that, but you definitely have to consent in writing to that, that representation. In most states, the seller pays the commission to the brokers, whether it's a residential or commercial transaction, but in many commercial transactions, you can negotiate that as part of the business terms that are negotiated between the buyer and the seller. So in the United States, there's two types of real estate agreements that are normally signed. An offer to purchase or a term sheet or a letter of intent is used in a commercial transaction. An offer to purchase is used in a residential transaction, and that's usually prepared by the broker at the time you're looking at the property. It's a fairly standard one-page document that normally has contingency for inspection and financing, and it sets forth the date of sale and the purchase price and when the deposits will be paid. The offer usually contemplates that a formal purchase and sale agreement will be negotiated, which is a much more detailed agreement. But just in Massachusetts, in the last 10 years or so, there has been a recent case law that says that a binding offer can be enforceable as a purchase and sale agreement, even though a purchase and sale agreement was ultimately contemplated. So you want to be very, very careful when you enter into an offer or term sheet or a letter of intent that there's specific language, at least in Massachusetts and probably many other states, that make sure that that is not binding until a formal purchase and sale agreement is actually executed by the parties. Due diligence, whether it's a commercial or residential transaction, you want to be careful about, in a residential transaction, you want to be careful about radon. It's not a huge problem. It can be easily resolved with the radon mitigation system, which is can be fairly inexpensive, but you definitely want to address it if people are going to be living in a lower basement or business operations or offices are going to be used in subterranean office space. Underground storage tanks are a big hot button issue. You want to make sure in a residential transaction that a property never had underground storage tanks, and even in commercial transactions, because that could create problems for a buyer going forward. Lead paint is a hot button issue if you're going to buy a residential property and use it for rental purposes, or even if children under the age of 6 are going to live in the property. So you want to make sure you might want to do a lead paint test if that's something that's important to you. That only affects properties that are built before 1978. UFI is urea foam formaldehyde insulation. It's something that has been a hot button issue for the banks, and so you just might want to point that out to your inspection if you're going to do an inspection and ask if the property has that. And septic systems. Here in Massachusetts, your property has to be inspected to make sure you have a working septic system. It has to be inspected within 2 years of the date of transfer. Forms of ownership for residential properties include not only individual separate homes, but condominiums and cooperative ownership. Here in Massachusetts, we don't have a lot of cooperative properties, but in New York City, if you're going to buy a condominium, if you're going to buy a residential home, be very careful, because you might be buying cooperative ownership, a co-op, so to speak. And in that case, you're not buying an individual unit within the building. You're actually buying a ownership in the entire building, and you have to go through stringent application processes and be accepted by the trustees of the cooperative. For condominiums, here in Massachusetts, we have what is known as a 6D, a Section 6D certificate, and you just want to make sure that the prior owner has paid all of the condo fees that are due on a monthly basis, and or assessments that might be assessed against your individual condominium over the last couple of years. So, and this is it also applies in many other states. So make sure that when you're buying a condominium, not only are you adjusting all other closing costs between the parties, but you're also making sure that the buyer has paid any fees that are due to the condominium as a whole. So forms of ownership here in the United States, I'm not going to touch upon this because we are assuming for the most part that you're going to be setting up a U.S. irrevocable trust, but I will talk about this slightly. Tenants in common. Two parties can own a property as a tenant in common. They each own 50% or 25%, whatever number of shares are being formed at that time. Tenancies in common have now become a form for investment properties, because people are setting up single-member LLCs and buying into these, investment properties in a tenancy in common form, and they're regulated or governed by a tenant in common agreement. For investment purposes, if you were going to invest in a larger office building or a shopping center, for instance, and you wanted to put in smaller money than the whole cost of an entire project, you can invest in this type of a format, or you can invest in what's called a Delaware Statutory Trust. The Delaware Statutory Trusts have very specific requirements. They're usually formed for single tenanted buildings with credit-worthy triple net leases. So if your interest is to invest in an income-producing property, you might want to consider one of these two forms of entities. For personal purposes, you can also buy the property as a joint tenancy, or if you're a married couple, as a joint tenancy by the entirety. If you are a married couple and you buy property as a joint tenancy by the entirety, you just want to make sure, you should know that creditors of the spouses can only attach the assets of that asset. The creditor of an individual spouse cannot attach an asset that's held as a joint tenancy by the entirety. Donna will touch on ownership of property in a irrevocable trust, but for the purposes of real estate transactions, what we have now do here in Massachusetts is, rather than put the entire trust on record for the public to see, you would file what is called just a certificate of trustee, and that is a very limited document that reflects the trustee and what is owned, and it sort of keeps a lot of the personal aspects of the trust document away from the public. records. Here in Massachusetts, we have a dual recording system. We have registered land and we have recorded land. Most property is held in recorded land format, which means whatever you take to the registry to record, whether it be a deed, a mortgage, a deed of trust, an easement, it's basically put on the system, not given any heightened scrutiny, and just recorded. And it's up to the person who's recording the document to make sure that all the T's are crossed and the I's are dotted. We have a heightened property registration system, which is called registered land, which is actually approved. Every document that's recorded is approved by the registry and blessed. So the land court is basically certifying every document that goes on record, and you have what's called so-called certified land. It's been blessed by the court in the sense that it's registered. Every document has been approved. All the easements and instruments of record are shown to be exactly what they should be and are registered with the court. Here in Massachusetts, we recently just amended our homestead requirements, which is a protection against creditors in the homestead of a person. If you filed a homestead declaration prior to 2011, it's still valid. You have up to $500,000 protection against creditors. New filings made after 2011 give you that $500,000 per residence per family protection against creditors. In other states, such as New Hampshire, you have an automatic homestead exemption without making without filing an actual document with the Registry of Deeds. But in Massachusetts, you do have to file a homestead declaration for the maximum credit protection. If you don't file, your protection credit is only up to $125,000. Trusts are now eligible for homestead protection here in Massachusetts. So if you own property in the form of a trust, you do get that homestead protection. And there's heightened protection for individuals over the age of 62 or those that are legally disabled. And the one other change is if you own a manufactured home, it's now considered a real estate interest and not a personal property interest when you file with the Registry of Deeds and not with the town offices here in the Commonwealth of Massachusetts. So your closing costs in Massachusetts include recording fees to record the deeds, to record the mortgages, to record easements. You pay transfer stamps, which are a tax on the actual transfer of the real estate. In Massachusetts, it's $4.56 per thousand. The seller pays the stamps. In New Hampshire, the seller pays half and the buyer pays half. And in Rhode Island, the seller pays the transfer stamps. And in many, many states, the transfer of membership interest in an LLC or beneficial interest in a trust are also subject to taxation. So you can't you can't avoid paying a transfer stamp by transferring a membership interest in an LLC or a beneficial interest in a trust. The parties, the buyer and the seller, will also adjust for utilities. Here in Massachusetts, in Martha's Vineyard and in Nantucket, if you're going to buy property on those two islands, it's subject to a land bank tax, which is a land preservation tax that is used for the purposes of buying land for preservation on those two islands. It's a tax that's paid by the buyer, so just be aware that if you're going to buy a residential home on those islands, you are subject to an additional tax in addition to the transfer stamp. And many properties in Massachusetts, Rhode Island, and some other New England states have been put into farm or agricultural status for farming incentives. And if you buy property out of those incentive programs, there is a rollback tax that has to be paid, and that can be pretty expensive. It's usually paid by the seller at the time that the property is pulled out of these farming programs. Other closing costs are if you're a foreign seller, not subject to U.S. tax programs, you have to withhold 10% of the amount realized from the sale. It is withheld by the buyer, so the buyer ends up being the withholding agent, and it's withheld from the proceeds that actually get paid to the seller at the time of the transfer. It must be remitted to the IRS by the 20th day after the date of transfer, and you file a Form 8288 with the IRS. If you're buying a property from a corporation in Massachusetts, there's an incohate lien which gets attached to all the assets of the corporation to confirm that the corporation has paid all of its withholding, sales, use taxes, whatever other employment taxes that might apply in the Massachusetts. So in order to purchase the property from a corporation here in the Commonwealth, you want to apply or have the seller apply for a tax lien waiver, and that's where the Massachusetts Department of Revenue will confirm that that corporation is current with its tax liability and that it is authorized to sell the assets of that company. This applies, I should back up and say that applies if it's the last asset or sale of all or substantially all the assets that that corporation holds in the Commonwealth of Massachusetts. So if it's just a piece of property and it owns other properties in the Commonwealth, you do not need to get a tax lien waiver before the transaction is consummated. If you own property in all of the United States, there are usual annual costs for ownership. You have to carry property insurance. If the property is in a flood zone and you're going to have financing on the property, you would also have to consider procuring a flood insurance policy. In the United States, we also pay on an annual basis, which are actually paid on a quarterly or semi-annual basis, depending on the town or city, ad valorem taxes, which are assessed by the city or the town on an annual basis and based on the value of the property. Every couple of years, the town or the city will increase or do a reevaluation of the properties, and the taxes will go up. In California, the taxes are not based on an ad valorem basis, but they're actually reassessed on the date of transfer. And so, if you own the property for 50 years, you continue to pay the same tax rate that you pay on day one as you do in year 50. In Massachusetts and most other states, you buy the property in year one, you'll pay a certain tax, and you will expect that it will go up on a yearly, every couple of years, so it's reassessed and revalued. For rental properties, in the state of Florida at least, there is a tax on rental income. It's usually paid by the lessee, and for commercial leases, the commercial landlord will usually pass that tax back on to the tenant. So, and I'm sure there's many other states that have taxes on rental income, so you should just be aware of that if you're going to buy investment income property. There's also personal property taxes on cars, boats, other personal property that might be kept in a particular town, so just be conscious of that. Some other land use issues you might want to consider if you're going to be buying property are permitting and zoning compliance requirements. If you intend to buy a residence or a commercial property and change the use, you definitely want to check into the permitting and zoning laws. Even if you're buying a residence, you want to make sure that you go down to the town offices and pull the building jacket or the building file and make sure that all permitting or reconstruction or refurbishing a property has been done in compliance with local permitting and zoning requirements and that all permits have been closed out properly. If you're buying property that is adjacent or to a waterway, there are special requirements with respect to renovating that property, side setback requirements, and it's not necessarily an ocean or a lake or a pond. It also could be just wetlands. So you want to be very conscious of that and look into due diligence matters that may concern those properties. Just for a couple highlights on things you should be also careful about, there's been recent case law in Massachusetts and many other states when you're negotiating a purchase or sale of property that email transmissions can be considered offer and acceptance. So just be very careful about not to negate emails altogether, but when you're getting really at the critical stage of negotiating the final terms of an agreement, people might consider certain email transmissions as a written offer and acceptance. So be very careful about that. And if you're buying property in Massachusetts or many other states, at least in Massachusetts, this is a very hot button issue that has come across our desk in the last 5 or 6 years. If you're buying property out of foreclosures, be very careful because there have been there have been recent cases where many foreclosures have been kicked back because the bank that has foreclosed on the property has not held the proper documentation. And this is basically all resulting from properties being transferred or mortgages being transferred in the secondary market, where banks are technically the holder of the mortgage and the note, but they don't have physical possession of the note, and or they're not the assignee of record because the records, the registration systems and the registry of deeds have not caught up with the assignments that take place in the secondary market. And so many banks have hold the paper on these properties, have foreclosed, but they physically have not been the assignee of record, or they physically don't hold the promissory note because they've been transferred through many banks in the secondary market. Those foreclosures could be rendered invalid. And so if you're buying property that's coming out of a foreclosure in the chain of title, you want to be very careful about that. Now I'm going to pass this on to Donna.
Do we have a question from
Oh.
I know we said we take
Yes, I should back. One of our colleagues pointed out that I should have made, a homestead is only valid on a principal residence. So if you're buying property in the United States and it's a second home, no homestead protection. Thank you, Marjorie.
Thank you, Amy. Now that we've looked at sort of the transactional issues associated with purchasing real estate in the U.S., what we're going to move to is the transfer taxes, the estate, gift, and generation skipping taxes that may be associated with the ownership of such property. We're going to focus on the taxes applicable to persons who are non-citizens and not domiciled in the U.S. Our tax code uses the word non-resident alien, which is a bit of a misnomer and can be a bit confusing. So I want to take a step back and just talk about what it means to be domiciled in the United States, because one can be resident in the state for U.S. income tax purposes, but not domiciled in the state for U.S. gift, estate, and generation skipping tax purposes. So what does it mean to be domiciled? Domicile is a question of intent. It's residing in the United States with the intent to remain there permanently. That's the way it is defined by the U.S. Treasury. So if one is residing in the U.S., even with a green card, and subject to U.S. income tax, one is not necessarily domiciled in the U.S. for U.S. transfer tax purposes. I want to make that explicitly clear, and I think people often confuse those two concepts. So if one is a non-citizen, non-U.S. domiciled person, the ownership or transfer of U.S. real estate or U.S. tangible personal property may be subject to transfer taxes. The first tax is the gift tax. There is a federal gift tax on transfers that for less than adequate consideration. So it may be that the gift is only a partial gift, if there was some consideration associated with the transfer of real estate. Some U.S. states have their own separate gift tax scheme. It's actually quite unusual. Connecticut in the Northeast is a state in particular that has a gift tax scheme. A non-citizen, non-U.S. domiciled person has a $14,000 annual exclusion from the gift tax for non-spousal transfers and a $145,000 exclusion for spousal transfers. In both cases, these transfers must be of present interest gifts. So what does that mean? If I have $14,000 and I give $14,000 to Brian, and Brian can go and spend the $14,000 and buy a car, or maybe not, a part of a car.
A used car.
A used car. Then Brian has a present interest in that $14,000, and I'm allowed to use the annual exclusion to exclude that gift from the gift tax. On the other hand, I take $14,000 and I hand it to a trustee of a trust of which Brian is the beneficiary, and the trustee determines whether or not and when Brian will be able to use that $14,000. He does not have a present interest in the gift, and I do not get an annual exclusion from the gift tax. I'm going to pay a gift tax on that $14,000. There is a method that we use in the U.S., in particular with irrevocable trusts, where I give $14,000 to the trustee of the trust for Brian, and the trustee sends a letter to Brian in accordance with the terms of the trust and says, Brian, Donna just gave me $14,000, And for the next 30 days, you can withdraw the $14,000. And if you don't withdraw the $14,000, it will forever stay in the trust and become part of the trust corpus. In that circumstance, that 30-day window that Brian has to withdraw the funds from the trust is sufficient to give him a present interest in the gift, and is sufficient to allow the use of the annual exclusion. And I'm sort of belaboring this point a little bit because I think there may be some circumstances later on in the presentation when we're talking about maybe a Canadian citizen not domiciled in the U.S. who owns property in their own name, and we're trying to figure out at that point how to get that property from the Canadian citizen to an entity that will prevent that property from being taxed at the death of the Canadian citizen. And this may be a method that we can use for that purpose. The gift tax rates are start about 18% and top out at 40%. And here's my domicile slide, out of order. So we've already gone through the definition of domicile, and it's a bit out of order. The one thing I didn't mention in the previous discussion was the flip side of a green card holder not being subject to transfer taxes because their intent is always to return to Canada is that a non-immigrant visa, where specifically as a condition of the visa, one states that one does not intend to be permanent in the U.S., could in fact, because of the intent of the person, be domiciled in the U.S. and subject to transfer tax purposes. And there was there's case law to support that position by the IRS. So there's a flip side to this intent test for U.S. domicile purposes. Moving on to the estate tax. The estate tax and the gift tax is a unified system in the U.S. The estate tax is a federal tax on property that's transferred at death. It's a tax on the full fair market value of the assets at death. So a Canadian citizen non-domiciled in the U.S. owning property in the U.S. in their own name would be subject to the estate tax at the property's full fair market value at the date of their death. The exemption amount available to a non-citizen, non-U.S. domiciled person is only $60,000. It's a much smaller exemption than what is available to a domiciled a non-citizen domiciled person or a citizen, which is currently $5.34 million. A non-citizen, non-domiciled person, however, may make use of a qualified domestic trust to obtain a full marital deduction for property that he or she transferred to a surviving spouse. And the domestic trust is much too complex to get into in this presentation, but just let's suffice to say that it's a lifetime trust for the spouse with a U.S. trustee. There are some estate tax benefits under the Canadian-U.S. tax treaty. A non-domiciled, non-U.S. citizen can claim a portion of the $5.34 million credit that's available through the treaty, and it's calculated using U.S. assets over worldwide assets times the credit available. The credit for U.S. estate tax purposes is an index for inflation, so that number will continue to go up over time. There was also a treaty marital credit and a QDOT available to U.S. citizens residing in Canada and Canadian citizens residing in the U.S. I just want to point out that these treaty benefits, while they're available against the federal estate tax, may or may not be available against the state estate tax, depending on how the state estate tax schemes are connected to the federal estate tax. Massachusetts estate tax system is built off of the federal system, and so it's likely that in the U.S. the treaty marital credit and would be available, but that's just something to be aware of depending on which state you're in. Generation skipping tax, the third tax. And a generation skipping tax is a tax that applies when you're transferring property 2 generations below the transferor, or if it's an unrelated person to a person 37.5 years younger than the transferor. It's a very onerous tax. It's a 40% flat rate tax. All three taxes, we're reviewing all three taxes because what we want to get to is how are we going to own real estate in the United States without being subject to these taxes? Again, the Massachusetts tax, many U.S. states, almost all of them have an estate tax system or an inheritance tax system. Massachusetts exemption is $1 million with a top rate of 16. Ownership of U.S. real property and tangible property will subject you to the state estate tax in addition to the federal estate tax. Now, and again, the state tax system may not be paired with the U.S. estate tax return, and in those cases, may be outside of the treaty benefits on the state estate tax side. So what I want to move on to is, so how exactly are we going to try to own real estate in the U.S. if you're a non-U.S. citizen, non-domiciled person, and avoid all of these owners' taxes? If you were here for the prior presentation, you'll be aware that a U.S. revocable trust or a Canadian residence trust would not be a good choice. The U.S. revocable trust is going to result in the application of the estate, gift, and generation skipping tax here in the U.S. because the trust is revocable. It's also going to be subject to the 21-year deemed distribution rules in Canada, which were talked about extensively in the last presentation. The Canadian residence trust, which was discussed in the last presentation, is also subject to the 21-year distribution rule. And if it's revocable, again, will be subject to U.S. estate, gift, and generation skipping tax exposure. So there may be, many ways to avoid the taxes. And for one trust in particular that I want to focus on, because we have a limited amount of time, is a non-grantor foreign trust to hold U.S. real estate. If it's properly structured, it will avoid all U.S. estate, gift, and generation skipping tax, and it will avoid the deemed distribution rules in Canada. So what exactly is a non-grantor foreign trust? A foreign trust is a trust where there's no non-U.S. person who has authority to control any substantial trust decision. So we want to have trustees who are not U.S. persons. And to be safe, you want to have those non-U.S. persons controlling all of the substantial decisions of the trust. I don't think we don't want to have a U.S. person controlling trust decisions. Even though you set up the trust with a non-U.S. person as a trustee, you also have to be careful about who controls who that trustee role is filled with. So if you have a U.S. person who can remove and replace the non-U.S. trustee, they'll be derivatively moved back to the U.S. person. They will be in control of all the substantial decisions of the trust, and you won't have a foreign trust. So who is a U.S. person? A U.S. person is either a citizen or a resident, or a U.S. partnership or a corporation. What does it mean to have a non-grantor trust? Simply, it means that the person other than the grantor or there must be persons other than the grantor or the grantor's spouse who are beneficiaries of the trust, whether the trust is purely discretionary or otherwise. So we'll talk about sort of a typical setup later in the slides, but if you have one spouse funding a trust for the benefit of another spouse and the children of that couple, you will have a non-grantor trust. If you have one spouse funding a trust for the sole benefit of the grantor spouse, you will not have a non-grantor trust. So what does a typical structure look like? We have an irrevocable trust. We have a grantor who's going to fund the trust with cash, and the trust is going to purchase the real estate. And the reason that we want to fund the trust with cash and then have the trust purchase the real estate rather than have the grantor purchase the real estate and then use the real estate to fund the trust is the transfer from the grantor of U.S. real estate to the trust will be subject to gift tax. So if in circumstances where you can actually plan the transaction well, you want to fund the trust with the cash to make the purchase and have the trust actually make the purchase and avoid all of the U.S. gift tax. One thing you want to be careful there is there's a concept in U.S. tax law of step transactions. So if you have this transaction all put together and there's been lots of discussion among counsel and accountants and the client about how it's going to be set up, and you fund the trust the day before, or you fund the trust the morning of the real estate transaction, and then the trust buys the property in the afternoon. The risk is that the IRS will look at that transaction and step it together and say that really what happened is the grantor purchased the real estate and funded the trust with it, and you may be subject to gift tax. So when you have the opportunity to plan well, you want to get your trust funded as early as you can. It's not always the case, but if you can do that, that would be best, and avoid any argument that the transaction should be stepped together into one transaction. A typical structure would have the grantor spouse as the trustee, the grantor spouse being a non-citizen, non-domiciled person. And in order to have the grantor spouse as a trustee and also as a beneficiary, the standard for distributions to himself or herself needs to be an ascertainable standard. That's a defined term under the U.S. Code. Typically means that the grantor spouse can make distributions to himself or herself for her health, education, maintenance, and support. You also want to have other beneficiaries of the trust in order to keep the trust, to have the trust qualify as a non-grantor trust. You want to make sure that the non-U.S. trustee has control of substantial trust distributions. Again, it's best if the non-U.S. trustee has control of all of the trust distributions. So there's no argument as to whether or not a decision was substantial or not. You want to make absolutely sure that your grantor or that your trustee beneficiary is not retaining any powers that would tie them back into the U.S. tax system. There are many, many strings in the U.S. tax system, some of them not so obvious, that will pull property back to a grantor or a trustee beneficiary. For instance, an example would be the grantor has the power to remove and replace trustees, and their ability to replace the trustee is not limited in any way. If a grantor can retain the power to remove and replace trustees as long as the replacement trustee is neither related nor subordinate to the grantor. It's one kind of a string. You want to make sure that the grantor retains no benefits from the trust. Another particular benefit might be the trustee's ability to discharge the grantor's legal obligations of support to a minor beneficiary of the trust. This is especially applicable where you have children, minor children who are also beneficiaries of the trust. If the trust is ever holding life insurance, the grantor's power to borrow against a policy would be an incident of ownership and also something that would pull something back to the grantor. So we've reviewed what the tax system is, the tax system applicable to ownership of U.S. real estate and tangible personal property. We've looked at a potential use of a non-grantor foreign trust to own real estate in the U.S. And now I'm going to turn to Brian. He's going to focus on the income tax issues associated with the ownership of vacation property by irrevocable trust, in particular an irrevocable foreign trust. He's also going to talk about domestic trusts. As you may have domestic trusts already, clients with domestic trusts that already own real property here and need to know what the rules are with those. Brian?
Thank you, Donna. So now you have your non-grantor foreign trust, your irrevocable foreign trust, and it holds U.S. real property, and the property is available for the use of the foreign beneficiary's personal purposes. Let's assume that all that's happening. Are there any tax consequences? No. For income tax purposes, the beneficiary's use is not taxable to the beneficiary or to the trust. There's no imputation of income based on the value of the rental use of the property or any such computation. The beneficiaries are free to use the trust for whatever purposes they deem beneficial. But many times the trust will hire a real estate manager and say, look, when the trustee will instruct them, when the beneficiaries aren't using the property, we would like to receive rental income from the property, and it may be for a substantial period of time, it may be for a short period of time. What happens then? Well, If the trust receives U.S. source rental payments, those payments are generally subject to a 30% withholding tax. They're treated as passive income, and the tax applies to the gross rental payment. No benefit is allowed for any of the rental expenses that one would normally receive if they were renting real estate. For instance, if you, as a U.S. Person, had a vacation home and rented it out, you would be able to take, your ordinary rental expenses against that income. Not so with foreign ownership. And the U.S.-Canada Income Tax Treaty does not provide for any reduced tax rate. It's 30%. However, the U.S. tax code does give the trustee the option to make an election to treat all of the rental income as effectively connected with a U.S. trade or business, as opposed to treating the income as passive investment income. In those circumstances, it's an irrevocable election, but the withholding does not apply, and the associated deductions, including depreciation, all become available. The trust, however, would have to file a U.S. income tax return, and to the extent that the trust retains the net rental income and does not distribute it to the beneficiaries, the trust would file a tax return and pay tax on the income. But to the extent that the beneficiaries receive distributions of the rental income, the beneficiary also would have to file and report the income, the net rental income to the IRS. But there is an exception for de minimis rental. It applies in very specific circumstances. If the beneficiary uses the vacation home as a residence, and the vacation home is actually rented for less than 15 days, then none of the rental income is taken into account for U.S. tax purposes, and at the same time, no deductions are allowable. What's a residence? Well, the beneficiary's use of the dwelling is going to determine whether or not the rental property is also the beneficiary's residence, and it's based on personal use. So if the home becomes the beneficiary's residence when he or she uses the property for the greater of either 14 days or 10% of the number of days rented at fair value. So, and there are attribution rules used by relatives of the beneficiary, and certain other persons can be attributed to the beneficiary in terms of determining whether or not the beneficiary has reached the requisite personal use. But because these circumstances aren't going to apply in every case, we need to know what's going to happen in some of those other cases. For example, we have two other possible scenarios. The vacation home could be rented for less than 15 days, and the beneficiary's use is too infrequent for the dwelling to become the beneficiary's residence. For example, when they use it for less than 15 days. In that case, the tax code will require the trust to allocate expenses between rental use, if any, and personal use. Only days of use are considered. So, for example, if the property is only used for 30 days during the year between rental use and personal use, the allocation is based on a denominator of 30 days. The other scenario is where the beneficiary's use is sufficient for the dwelling to qualify as his or her residence, i.e., the beneficiary uses it for more than 14 days, and the dwelling is rented to others for more than 14 days, so therefore the exception that would render the rental income not taxable at all does not apply. In that case, again, the expenses are allocated based on the total number of days the property is used either personally or rented, but there's also a second limitation that springs into action. The gross income limitation applies, and that caps the expenses that are available with respect to the property at the level of rental income collected. Let's take the first scenario. The vacation home is rented for 10 days, which is below the 15 days, so it may qualify for the rental income exclusion. However, the beneficiary uses the vacation home for only 10 days, so therefore it's not a residence. What happens? Well, because the beneficiary's use is insufficient to qualify the dwelling as his residence, the exception for rental of a dwelling, for rental income, the rental income exception does not apply. All the rental income is taxable. The expenses have to be allocated based on the days of use between the rental period and the personal use period. And so, for example, in this case, only 1/2 of the expenses associated with the rental of the property or the use of the property would be allowable as rental deductions. The next example is where the beneficiary's use is sufficient for the dwelling to become his residence, and the dwelling is rented for more than 14 days. In that case, let's assume the beneficiary uses the vacation home for 20 days. It's a residence, but the vacation home is rented for 20 days, exceeding the 14-day cap for the rental income exclusion. What happens? Again, the exception doesn't apply. All the rental income is taxable. The expenses have to be allocated between personal use and rental use. And again, only 1/2 of the expenses are allowable as rental deductions. But then the gross income limitation is triggered as well. The gross income limitation is gross income reduced by deductions allowable without regard to rental of the dwelling. For example, U.S. Taxpayers, including trusts that own rental real estate, would be able to deduct their real property taxes, but those reduce gross income, and then that remaining amount is the extent to which all of the other allowable expenses, after you apply the allocation based on use, is allowed. Any amount that's unused in the current year can be carried forward as a deduction in succeeding years. What happens when the property is sold? Well, because it's an irrevocable trust, that's a foreign trust and not a grantor trust, there's a 10% withholding tax that applies to foreign persons, including the foreign trust in this circumstance. So the buyer of the property has to withhold 10% from the amount realized by the seller. However, there's no additional withholding requirement imposed on the trust itself, and there are some exceptions. For example, if the sale by a foreign trust of property if the property is acquired by an individual purchaser who will use the property for his or her personal residence, then and it's acquired for not more than $300,000 US, then the withholding you're exempt from withholding. It doesn't apply. But regardless of whether withholding applies, the trust should report the sale on a U.S. income tax return. And the amount withheld from the proceeds, if any, can be taken as a credit against the tax return liability. Again, the U.S.-Canada Income Tax Treaty does not provide a reduced withholding rate or a reduced tax return rate if the sale is reported. If the trust interest is disposed of instead of the actual real property, there is a current exemption. A foreign beneficiary can dispose of an interest in a U.S. domestic trust or a foreign trust, and it's currently not subject to withholding. It may be in the future, but it requires the Treasury Department to promulgate regulations, and they have yet to be issued. So at this point in time, it's a loophole, and one that we would urge you to look at if you're in a situation where you want to dispose of the real estate without being subject to the withholding tax.
Thank you, Brian. We're going to move on from the vacation real estate issues to legal and tax issues when administering U.S. assets. So these are issues of probate in the United States where we may have Canadian ownership of the assets. So in Massachusetts and in the U.S. states generally, in a testate situation where the decedent has a will, there will be an ancillary probate required in the U.S. And what we would need is what's referred to as an exemplified copy of the Canadian Probate Authority. So you do your original probate in Canada, obtain an exemplified copy of that, and then there's a filing done in the U.S. in the state where the real estate or the asset that needs to be transferred is located. There will be sureties required on a probate bond for the personal representative, the ancillary personal representative who is appointed. Those can be waived if all the heirs at law consent, or if the will directs that those sureties should be disposed of, or the court allows it on motion. So any real and personal property down here are going to need this ancillary authority. I want to turn it back to Amy just to mention the possibility that one would need to get a license to sell real estate from the probate court in the context of an ancillary administration.
So Donna's correct. So if you have a testamentary trust or an estate with a will where the personal representative does not have the specific right to sell the property or authority to sell the property, or if you have a corporate trustee who might want some protection from liability on the sale of a piece of real estate, you would make a condition of the purchase and sale agreement, or the purchase and sale or the transaction the transaction contingent upon the seller getting a license to sell from the probate court. And it can take or add some extra time to the closing, but you usually do it simultaneously with the buyer's due diligence period. And it's basically a fiduciary obligation for the fiduciary to get the best and highest offer. So you don't take into other considerations of the sale, whether it's a cash deal versus a finance deal. It's basically the best and highest offer. In many circumstances, the personal representative will even put the property out to auction between competing bids to get that best and highest offer. Once the license is issued, you're also not done, because if another offer comes in after the license is issued, you are directed to go back to the court, resubmit the new highest and best offer, get a new or amended license to sell. So, the property, for a buyer, it's always open to somebody else coming in and taking the property from under you if they come in with a higher offer.
Thank you. So moving ahead to an intestate situation where the decedent had no will, again, you would need to do the initial administration in Canada and then obtain an exemplified copy of those probate proceedings, bring them down to Massachusetts, our appropriate state, and file for an ancillary administration appointment of a personal representative. There's no prohibition in the U.S. for, at least in Massachusetts, there may be a rare state, but in general, there's no prohibitions against non-residents, non-citizens serving as ancillary personal representatives. The most that would be required is that there would need to be an appointment of a resident agent for the service of process. So if the estate was sued, there needs to be somebody physically on the ground in the state where a complaint can be served. Again, you're going to have sureties on the bond unless all of the heirs at law of the decedent consent or the court waives on motion. And whether or not a court will waive sureties in either case is really dependent even on a county system within a state. So it's not even a state-specific issue. It's a county-by-county issue, what the court will take into consideration. Just as we discussed in the prior presentation, land and tangible personal property and how it's distributed in an intestate situation is going to be governed by the law of the situs. So in particular here, it's going to be governed by the law of the state, situs laws of the state, and the intestate succession laws of the particular state. Intangible property is going to be governed always by the domicile of the decedent, and so a Canadian citizen or Canadian domiciliary, the intangible personal property is going to be governed by Canadian law. One thing I just want to caution on is there are a number of community property states here in the United States, California being the most well-known of them. Massachusetts is not a community property state. We're a common law state. A community property state deems all property of a couple to be owned 50-50, no matter how it's titled. So it can be very confusing. So you may have a situation where you have a bank account in California, ostensibly intangible personal property, that is deemed to be community property by the state of California. And so there may be some conflict of law issues as to how that property would pass, regardless of how it's titled. So it could be titled all in the name of the decedent spouse, but the state of California would consider that property as owned 50% by the decedent and 50% by the surviving spouse, notwithstanding title. There are some cases that say that even a non-domiciliary of the U.S. or a non-domiciliary of the state of California, so this is a state versus state issue as well here in the U.S., by opening an account in the state of California have subjected themselves to the community property laws. And so you may have some confusion on intangible personal property in the U.S. on those issues. So intestate succession, I'm just going to limit this to the Massachusetts rules, because those are the rules that we know here in Massachusetts. We've just adopted the Uniform Probate Code, which has been adopted by a fair number of the states. And the general scheme, I have it detailed in the slide, but the general scheme is that if we have a couple and one of the spouses has died, and there are children of the marriage, and they're the only children of this couple, and this couple has no children outside of the marriage, no prior marriages with children, there were no children born out of wedlock prior to the marriage, then all the property is going to pass to the surviving spouse. If you have a surviving spouse and no descendants, and you have parents, you're going to have some of the property passing to the parents. If you have children of either spouse, the surviving spouse or the decedent spouse, outside of the marriage, and children also of the marriage, you're going to have a different scheme where the spouse is going to receive less and the surviving children are going to receive a bit more. So who is a spouse for these purposes? I know we talked at the last presentation about common law marriages in Canada. There are no common law marriages are not recognized in the state of Massachusetts, meaning that if Brian and I, although we're both married, if Brian and I are living together for 2 years, we're not going to be deemed to be married under any circumstances, no matter how we hold ourselves out under the laws of the state of Massachusetts. There are a few states in the U.S. that do recognize common law marriage, but they're in the minority. Spouses, of course, are going to include people who are married. It will also include married same-sex couples. And in the U.S., the courts are going to deem whether or not a couple is married based on the law of the state where the couple is domiciled. In the recent case by the Supreme Court last year that overturned the Federal Defense of Marriage Act, which now provides that the federal government will not discriminate against same-sex married couples in any of the tax codes, also pointed out that this is a state law issue. It's not an issue for federal law to be involved in. And that's the way the states typically look at it. It's the law of the state where the couple resides that has the most contact with the couple, or where the couple were married, are going to determine whether or not you are a spouse for the intestate succession purposes. And so that may raise an issue with the Canadian common law marriage. I know I spoke to Tammy earlier in the week about whether a common law married Canadian couple can obtain some documentation of their marriage. And if they could obtain some documentation, whether it's governmental documentation or court documentation, that documentation may be sufficient to be submitted to a probate court here in the U.S. to prove the marriage, even though common law marriage isn't readily acceptable here. And again, it would have to be a marriage that didn't violate the public policy of the state where the marriage is hoped to be recognized. So if it was a multi-spouse marriage, not likely that was recognized in another country, not likely it'll be recognized by a court in the Commonwealth, but a common law marriage with documentation from Canada would likely be recognized. I just have some very few specific assets. I'm trying to mimic the presentation, the prior presentation. In the prior presentation on the Canadian issues, there was, I think Ontario had a rule where the estate paid the shipping costs for changeable personal property to a beneficiary. Here, there's no statutes that govern that. A will might typically say that the executor shall pay shipping costs of changeable personal property. It may say they may pay shipping costs, but it's not a conclusion that the estate will be footing the bill to move the changeable personal property up to Canada. Retirement assets are, a unique asset here in the U.S., subject to U.S. deferred income tax. There are ways that one can receive one's inherited IRA in a way that will defer the income tax out over the longest possible period of time. And one of those ways is through what we call an inherited IRA. Again, it's not a topic that we can get into in any detail here. Okay, our last segment is on spousal claims against estates. And in the last presentation, there was a great deal of discussion about the rights of persons, parents, children who were not benefited by an estate to make a claim against an estate in Canada. That's a very limited circumstance here in the U.S. And in fact, the first time I heard about this right in Canada, I was really quite shocked. Spouses cannot be disinherited from their spouse's estate, and if they are, they receive either less than what the value of what's referred to as their elective share, or they receive nothing. They can elect against their spouse's estate, against their spouse's will, to receive their statutory share or their elective share. The size of the share and the property from which it is paid varies state to state. This is a state law issue. Even where there is statutory law and case law, like here in Massachusetts, it can often be very unclear from what property the elective share can be made. In Massachusetts, the elective share is antiquated. About 30 years. It's been about 30 years since the courts made any effort to expand it. Spouses may end up with less than they would end up even in a divorce situation. We had a recent case here in the office where a couple was in the process of getting divorced, and the amount that the spouse would have received in the divorce proceeding had her husband not died would have been substantially larger than she will see as an elective share. Often, if there's concern that a spouse may elect against a will, there'll be an effort to try to provide the spouse with something slightly more than the elective share in order to avoid the disruption of the tax planning and other planning that's done in an estate plan that's undone if an elective share is made. Claims by descendants. Really, there's no right for a child or a grandchild of a decedent to make a claim against an estate if they're not provided for. And probably in every single estate plan that you'll see in the U.S., there'll be some expression that says, if I have not included one or more of my issue or my descendants in my will, I've done so intentionally and not by mistake. I mean, that is the standard. You can intentionally disinherit your children or any of your issue for descendants, and it's only in the case where a descendant could show that if the decedent just forgot me, who otherwise would have provided for me, that you would have a claim by a descendant. In situations where we are concerned that a child who is being excluded may make a claim against the estate, we would include inter rorum provisions and some benefit to the disinherited child. Inter rorum provisions are provisions that provide that if any claim is made against the estate for more than what's been given, that the person loses 100% of what they've been given. And so the idea is to give someone enough to make them think twice about making a claim against the estate and bring delaying the estate distribution with costly litigation. That is the conclusion of our presentation, and I think at this point we can take questions if there are any, or comments from any of the attorneys in Vancouver or Toronto.
Hi, Richard here in Vancouver. I think I have a few questions, and maybe some of our people here may have some questions as well. The first one I have goes back to the U.S. The credit. If an individual in Canada holds property directly in the U.S. and then transfers, or sorry, dies, there's the non-domiciled. There's the credit for the pro rata portion of the 5.34 million credit. And so first question is it safe to say that if the total estate is less than that threshold, the 5.34 million, then generally speaking there will not be U.S. estate tax? And then the second question, how settled in your view is the 5 million or 5.3 million exemption and the fact that that's going to be there in the future at this point, if you can predict the future? Thanks.
I think you are correct. So if the total estate is less than 5.35 million, 34 million, then you wouldn't be, then a Canadian non-domiciled person holding U.S. real estate would not be subject to would be subject to U.S. estate tax, but would be the tax would be absorbed by the credit amount. I feel quite settled that it would take quite a bit of political muster to reduce the estate tax scheme that's currently in place. And if you pay any attention to how dysfunctional our Congress is at the moment, I don't see they can get no important thing done. I can't see them getting focused enough on the estate tax to reduce it. So I feel very comfortable that we'll continue to have this 5.35 million, and it will continue to increase by inflation. I don't know if anybody else wants to opine on that. I stopped opining on it after we had no estate tax in 2010, which I never believed would happen. But I do feel pretty settled about that, especially given the dysfunction in Congress.
We'll stick with your optimism.
Oh, that's great. Thank you. The next question that I have here relates to the step transaction rules. So when we're setting up these non-grantor foreign trusts to hold U.S. real property, the point was made that the step transaction rules can apply if the trust is funded and thereafter the property is quickly acquired by the trust. So the point was made to fund the trust as early as possible, and we've run into that in transactions like this before. Would it also be a thought in those sorts of situations to actually fund the trust with more than what's required to purchase the property and maybe to hold some other investments in the trust? Does that help for the purposes of the step transaction analysis?
Well, if you... I think it certainly helps if you have even the smallest amount of distance between the funding of the trust and the purchase of the real estate. And one of the things that I didn't mention that I had intended to mention, because there have been cases in the U.S. where we've come up short on this, is just and I don't know how the confidentiality rules, the attorney-client privilege rules work in Canada. But if you're doing this sort of a transaction, in all likelihood, you're going to have likely to have a U.S. counsel either on the real estate side or maybe on the tax side while you're doing this transaction. So if you have, on the U.S. side, if I'm in a room with my client, I have attorney-client privilege. As soon as the accountant comes and sits in the room or somebody else comes and sits in the room, the discussion stops being privileged. And if you have a situation where all the discussion among the professionals is about, we're going to fund this trust, and we're going to fund it with just a little bit more because we want to avoid the step transaction, and we're going to do this all 2 days before we purchase the real estate, and you break the privilege by having an accountant in the room or someone in the room other than the attorneys and the client, that information can be discoverable by the IRS and support their step transaction analysis. So I just want to caution on that. But I think, yes, that, you know, anything you can do to help the transaction look like more than an exact funding of the amount needed to purchase the real estate and then a purchase of the real estate shortly thereafter will help. Every fact, it is a fact-specific analysis, and so every fact that you can put in play to avoid the step transaction is beneficial.
Can I jump in?
Sure.
So clearly, Richard, the planner does not want to, wants to strive to have a transaction that doesn't seem to be prearranged. So, for instance, the person has a signed purchase and sale agreement for the property and then decides to form the trust, fund it, and then assign the P&S to the trust. That's a bad situation in terms of the IRS trying to make a case that there's a gift of real estate and not a gift of intangible assets, which is exempt from the U.S. gift tax regime. But if the trust is funded with cash, I think your suggestion goes a long way. That, you know, it shouldn't be $1 million, $300,000, 24 and 33 cents if that's the closing, the amount on the closing statement. So, but I'm not too concerned about it unless it has all the indicia of being prearranged and some of the steps were taken before the funding of the trust. I think that's what you want to look at.
Well, thanks. That's helpful. And you know, as a follow-up to that, as a practical reality, you know, it would be great if clients came to us to set up these structures before they had the purchase and sale agreement, but often that's not the case. And so, you know, we're making the best with the situation that we have. And so I guess I wonder, as a follow-up to that, practically speaking, do you see these rules being applied, or is this something that the IRS is in fact going after? In other words, how big of a concern would you make this if I brought a transaction to you and said, listen, we want to set up this trust, the agreement was already signed, can we even do this?
Well, I think that you have to tell them that it's a risk, and that you can report the transaction as it's intended to be reported, but there's certainly a risk that if the IRS reviews it on audit, that they could make the challenge. And again, if you follow the black letter law, as long as it's a cash-funded gift, then technically you've complied with the rules. So,
Richard, it's not that we see a lot of situations where the step transaction is asserted, but it's asserted, and so we always, you know, we have it on the list as a risk, and it's a risk that we tell our clients. But it's not as though we're seeing the IRS, you know, always looking at step transactions. Like you, our clients come to us at the last minute with transactions, particularly, you know, at the end of 2012 when we thought the exemption was going away. We did all kinds of transactions, you know, in a 24-hour window, and we can only work with what we have. But it's really just if you have the opportunity to avoid it, it's out there and avoid it. And just to make clients aware of it, just in case you are the one situation where the IRS does come in and assert it. And again, they have to have an opportunity to assert it. And so it's, you know, we're not filing a gift tax return for this transaction. There's no returns being filed on this transaction that the IRS is going to scrutinize. And even though we're not supposed to talk about audit risk, since we're not allowed to do that, you know, the audit risk is very low. You'd have to find a circumstance of why is the IRS looking at this particular transaction? What is going to prompt the IRS to look at the transaction? So I think it's a pretty low risk.
There is a case out there, though, and I can't recall the name, but it originated out of Hawaii, where you had I think it was a Japanese citizen owned real estate in Hawaii, and a trust was established, funded with cash, and then the cash was used to purchase the real estate from the Japanese taxpayer, and they were all related parties. In that case, the IRS did find that it was a gift of the real estate by the original owner to the trust, and it was subject to gift taxes. So that's a situation that they have, you know, used. But so the takeaway I have from that is someone related to the transaction already owned the real estate. In that case, then you have a big issue. Purchase and sale doesn't go quite as far. Are we still on? Okay. A purchase and sale doesn't go quite as far as that, so I draw the line there.
Okay, thank you. Do we have any questions here in Vancouver? Okay, nothing further here. Thank you.
Thank you, Richard. Appreciate it. Toronto, do we have any questions?
This is Lindsay. We did have a question come in from Toronto via email. The question is, what is the difference between a Canadian residence trust and a foreign non-grantor trust that is a resident in Canada?
I'm going to bounce the Canadian Residence Trust question back up to Canada for Richard or Tammy to respond to.
Well, Richard speaking here. I think when we would normally talk about a Canadian residence trust, I think we would be speaking about what we would consider a domestic trust here in Canada, typically to hold a residence in Canada. That's how I would use that term, and that would be as opposed to the foreign non-grantor trust from the U.S. perspective, which is typically to hold U.S. property. So that's the distinction that I would make, but I'm not sure whether my colleagues in the other cities would have the same take on that.
I don't think we have audio coming in from Toronto, but they do have another question. If the individual purchaser of a U.S. property from a non-grantor foreign trust for less than U.S. $300,000 is a non-domiciled, non-U.S. citizen.
Again, the property has to be used as a residence by that individual, personal residence. So if that's the case and the purchase price is not more than $300,000 U.S. dollars, then the withholding rules that would require the purchaser to withhold on the proceeds of the sale by the foreign trust apply.
Was that response to the question, Lindsay?
Sounds like it.
It was framed as a question.
Yeah, no, I think that covers it. I don't know if Leonard and Tammy had any additional questions coming in. Okay.
The withholding tax is imposed on the seller of the property. So the fact that the buyer might not be a U.S. person shouldn't matter. But that buyer will have responsibility, either through the person's broker or real estate agent or attorney that's handling the transaction, to withhold if the purchase price exceeds the ceiling.
If we don't have any more questions, I want to thank everyone for participating in the webinar. We enjoyed having you, and I hope you got some information from the presentation. I also want to thank Clark Wilson and Fogler Rubinoff for participating as well, all the attorneys in both offices, and for all their work on the prior presentation. I think you can see on the screen all of our email addresses. If there are any questions that come up after we sign off or during the week or at any time, and please feel free to email any of us. We'd be happy to be helpful to you. Thank you.
Thank you.